Hello everyone. I believe you guys have seen or you guys have read independently, however it is on your own. The entire syllabus is done, and then come and watch this amendments part. So today we'll be recording the company law amendments for new syllabuses and applicable for June 2024 and onwards. So it can be applicable for June as well as December as well. So this is for company law, new syllabus, guys. So keep that in mind. Company law only has gone away. Okay, company law, new syllabus. Okay. So, sir, the amendments are in these chapters, people. Yeah. Certain amendments are important and certain are like okay. Overall, if you ask me, how is the amendments? I'll say that there is no much amendments for you for this attempt. Hardly it will be done in half an hour, 40 minutes. And I don't see any probable question as such from the amendments part. If it is important while doing only, I'll let you know that this particular part is important. Is clear all of you? Okay. The first one, sir, in introduction to company law, they have introduced something called as MCA establishes. This is in company law, first chapter. MCA establishes Center for Processing Accelerated Corporate Exit. What is this, sir? They have named this something called as people CPACE. They have named it as something called as CPACE. Now, what do you mean by this, sir? Technically speaking, is this amendment required for you? I would say the answer is no. Because earlier what used to happen, there was a topic only, people, called as strike off earlier in old syllabus. So for them this particular amendment was more relevant. For you guys, the strike off provisions itself is not there in syllabus. Now what is the use of me telling you amendments to that? Because strike off only is not there in your syllabus. So that's the reason I'm telling you, indirectly this particular amendment is of not of much of use for you guys. But still it is there. I'll tell you what is the amendment. At least it is good for you guys to know from, company law perspective. You guys are company law students now, you need to know everything. So, the CPACE, I will connect everything in one place. Okay, where is the STK? Okay. So they have given this strike off amendments only in two places. So what I have done, what I'm trying to do is trying to club that amendment as well as this amendment. So I'm just searching for that file. I'm not able to find. See that you guys also search if you guys can find something called STK2. Is it removed or what? Are you guys able to see? Are you guys able to find STK corporate social responsibility? Okay. Yes, sir. Here it is. Now, sir, so this and this are connected. You can find it under miscellaneous. There is one more amendment here. Both are connected. Now, what is this entire amendment? I'll tell you. Now, see here. Now, imagine people, whenever a company wants to shut down its business, there is a procedure called as strike off. What do you mean by strike off? A company voluntarily writes to the registrar of companies, that is ROC, saying that, sir, we would want to we would want to voluntarily wind up our business. And this process was called as strike off. Now what is happening, people? They have changed, they have brought in some amendments to this particular part. Now what are these amendments, people? To this strike off part, what they have done, whenever a company wants to voluntarily wind up their company, they used to file all their applications to an authority called as ROC, as it is, our registrar of companies. Now, Papa, already our registrar of companies is already overburdened with his work. Already so much of things are there, no? He needs to take care of too many things. So what is happening, people? Slowly, certain work from the registrar of companies is being taken away and it has been put to, or it has been given to few other authorities. Like that only, they have created a new authority, and that new authority and the new system created only is called as CPACE. Now under the CPACE, what is happening, whatever where the powers given to are ROC under MCA Act, the same powers are now given to one more person. So whatever the powers that can be exercised by ROC now will be exercised by another authority. Now that is only called as CPACE. The entire procedure, everything was same, just that the authority has been changed, and the new authority is what this particular amendment is. Now see here, what does it say? The registrar, this is a new person, the registrar, Center for Processing Accelerated Corporate Exit. You can see the name also. It is a center for what? I told you, they have created a new authority. They have created a new center. The center is for what? It is a center for processing accelerated corporate exit. Accelerated means people already ROC was overburdened. The time taken was more. So we have created a designated authority now. Now he takes care of only this corporate exits. So now the new authority now will be called as people Registrar CPACE. Registrar CPACE. So indirectly in the previous law, wherever we had given a cross reference to ROC, now ROC means this person, that's all. Rest and all the procedure is same. Sir, but all of this is important for us? Absolutely no, because you don't have the strike off thing at all. But they have added it. So overall, what is the picture? I explained you. Yes, sir. See here, an application for removal of name, meaning strike off, like voluntarily winding up, shall be made to the registrar Center for Processing Accelerated Corporate Exit in form STK2 along with the fees 10,000 rupees. You need to file it. Instead of filing with ROC, you will be filing it now to CPACE. According to the amendment, now the application in form STK2 shall not be accompanied by a copy of special resolution. Earlier we used to give some copies of special resolution and all. Now that is not required. This is not needed at all for you, so forget about it. The registrar of CPACE shall be the registrar of companies for the purpose of exercising functional jurisdiction of processing and disposal of applications made in form STK2. Meaning, sir, till now whatever were the authorities, whatever were the functions that was carried on by ROC, now the entire thing will be carried on by CPACE. That's all. Registrar CPACE. That's all. That's the amendment. Yes, sir. Technically not at all required for you, but it is there. I'm just explaining. That's all. Clear or done? Not done. Okay. Yes, that's what is the new thing. See here, Honorable Finance Minister Nirmala Sitharaman during Budget Speech 2022 stated that Center for Accelerated Corporate Exit to be set up to accelerate corporate exits. In view of the same, MCA wide issuing notification dated March 17, 2023, it has established a CPACE. The CPACE be located at Indian Institute of Corporate Affairs, Manesar, Gurugram. It will be effective from 1st April 2023. Understood? Yes, sir. Okay, done. Next one, sir, share and share capitalisms. Here, sir, what is the amendment, sir? Through amendment in Rule 17, the changes to the provision relating to buyback of shares or other securities has been made. The requirement of annexing means people attaching. The requirement of attaching a certificate along with the return in form SH11 has been substituted with submitting of a declaration instead. What we used to do, people, earlier we used to attach a certificate along with form 11, that is form SH11, about the compliance with the procedures. Now instead of certificate, it has been called as a declaration. Now when we'll be doing this, people, SH11 is nothing but a return of buyback. Once the buyback is done, you guys will be filing the form. So in that, this particular amendment has come. Okay, this declaration must be signed. Now you're filing a declaration, no. This declaration must be signed by 2 directors of the company, including MD, if any, managing director, certifying that the buyback of securities has been made in compliance with the provisions of Act and the rules made thereunder. Earlier we used to call it as a certificate, now you are calling it as a declaration, meaning you are signing under your signature that you have followed the entire rules and regulations properly. And this has to be declared by 2 directors. In that, one at least has to be managing director. Additionally, amendments has also brought revisions in the following forms in SH7, SH8, SH9. Already these forms were there. In the existing forms, people, they have added or deleted some information. But is this important for us? Absolutely no. Why? Before the amendment, what and all the information was there in the form, you already don't know. Because it is not there in your syllabus. So if there is any changes that is happening in the form also, that is also not required for you, because you do not know what was there. You don't know what is there now also. So because of that, these things will not be so important for you, even from exam point of view also, or even otherwise also, until you start going for articleship. Clear? I'm done. Next one, sir. MCA prospectus and allotment amendment. Okay, what is this, sir? Through amendment rule 12.6 has been omitted, which was earlier requiring in the case of the issuing of bonus share, a copy of resolution passed in the general meeting authorizing the issue of share shall be attached to PS3. What is this, sir? Earlier, people, whenever we used to do bonus issue, once the bonus issue is completed, we will intimate ROC, right? That, sir, we have issued so many shares. What is the type of share? Everything we used to intimate. We used to intimate in the form PAS3. Now, to this PAS3, there was one attachment. What is that attachment? We used to give something called as the copy of resolution. Meaning, if you have passed a special resolution, you used to attach the special resolution to PAS3. Now, people, they are done away with this particular attaching of resolution. PAS3 is still filed, but you need not attach that resolution to that particular form. That's all. Important or no? Okay, that's all. Sir, reduction of timeline for listing of shares in public issue from existing T+6 to T+3. Now, what is this, sir? Whenever a public company is going for an IPO, people, whenever a company goes for an IPO, now for the company, now imagine, people, this company, whenever they want to go for an IPO, there will be something called as offer period, during which you guys can buy the shares of the company. This offer period generally will be for minimum 3 days. Once the last day of offer period is done, now the offer is completed. Now what will the stock exchanges do? They will convert all that. They will take the, the procedural formats and all will be done. And technically it used to take around 6 days for the company to start trading on the stock exchange. Now they have reduced this timeline from 6 to 3 days. So now technically, once the 3 days offer period is done, now within 3 days, people, the company will be listed on a stock exchange, meaning the company can start trading. Earlier it used to be 6 days, now it is only 3 days. They have reduced the timeline. That's what is written here. See, SEBI, consequent to extensive consultation with the market participants and considering the public comments received pursuant to consultation paper, reduce the time taken for listing of specified securities after the closure of public issue. So once a public issue is closed, offer is done, 3 days is done, minimum is 3 days. It's done. Now, people, it used to take 6 days for the company to get listed. Now it has been reduced to 3 days. That is the amendment. T being the issue closing date. Meaning, I told you, offer period is open for 3 days. Imagine it is open for Monday, Tuesday, Wednesday. So from Wednesday, that is a T day. From Wednesday, it will be 6 days. That's how you calculate. Sir, 6 days means also technically, people, this is 6 working days it used to be. Yes, sir. Now see, where is it? See, it used to be as against the present requirement of 6 working days, they have made it as, people, 3 working days. So it will be Wednesday is my last day. So it will be T plus 3. So it will be Thursday, Friday. Saturday and Sunday are not working days. So Monday will be considered as a T plus 3. So by Monday it will be listed. That's how you need to see this. Clear? Done. Next one, sir. The company's prospectus and allotment of securities. Second amendment. Okay. So people, this is a little important, people. This one is a little important. Okay. So there are 2 amendments here, people. This is 1 and 2. The second one is, people, important. I think there can be a question here, so concentrate. So now what is this amendment, sir? Earlier what used to happen, people, there is a concept of something called as share warrants. About this concept, there is no much thing in your syllabus. You will be generally seeing this in capital market paper. In company law, there is nothing much about share warrants. But I'll tell you what is share warrants. Share warrants are nothing but people. It is like a convertible note only, where today I'm going to issue something called as share warrant. Now, what is the meaning of share warrant? Imagine the company issues a security called as share warrant. Now, who will get this? The public will buy this share warrants, or say any person. It can be private people also. So these people will buy the share warrants. Now, what is share warrants, people? Share warrants are nothing but those securities. Immediately, you need not pay the complete money. Let us imagine, sir, the company wants to say, for example, there is an equity share. The company is selling the equity share. Now, for example, imagine there is a company called as Paytm. Paytm share price was 1,500 rupees per share. According to, I'm just giving you an example, as per their IPO. Now, for example, I do not know whether this company is worth investing or not. I don't know if this 1,500 rupees is worth. What if after I investing, the company starts falling down? What if that happens? So what does the company do? The company only gives you an option. It is optional. It is on company's part. If they want, they can do. Today's date, it does not exist also. So what is share warrants? In companies at 1956, it was more predominant. So what used to happen? People used to take share warrants. Now they get an option. Now what is that? Upfront, people, they will not pay the entire 1,500. Then they will pay somewhere around, say for example, some 25% of the share. Imagine people, they pay around, I will just take an example of some 300 rupees. The shareholder, of instead of paying the entire 1,500, will just pay around 300 rupees per share. With an option that what? Now, say for example, wait for 1 year. In the 1 year, if you think the company is performing good, then do one thing, pay the remaining amount also. If at all in the 1 year, you take Paytm example, now it has come and, it has settled at rock bottom, 350 rupees. Now, I anticipated it to go up, but it went down. So, what you can do, whatever is the 300 rupees you gave, that will be left. You will not convert it into equity share. You will let it lapse. Now, this type of option given to a shareholder is called as share warrant. You will have an option to convert it into equity if at all you desire to do it. If not, people, you can let it lapse. Now, this is called as what, people? This is called as share warrant. Earlier, what used to happen in companies at 1956, there was no last day for you to pay the complete amount and to convert it into equity share. There was no last date prescribed. So, what people used to do? People used to just take their own time. Now what they have done in amendment, in whoever are the companies, whoever have issued share warrants under companies at 1956 have been given deadline. And what is the deadline? Within some time, you guys have to first tell who and all are still holding share warrants without converting it. You have to first give a declaration, and within some other time, you need to convert it into the security, whatever you issued it for. Imagine if it is equity, you need to convert it into equity within a certain period of time. And whatever time, within 3 months, you need to give a declaration, within 6 months, you need to convert. That's the complete amendment. Understood? See, within a period of 3 months, the commencement officer shall inform the registrar about the details of share warrants in Form PAS7. You first inform. And within a period of 6 months, the bearers of the share warrants to surrender such warrants to the company and get the shares dematerialized in their account. For this purpose, the company shall place a notice for the bearers of share warrant in Form PAS8. Meaning what, sir? I need to give a notice now that this is the last day and all that. So the company will put it on its website, company will put it on the newspaper in the Form PAS8 that within 6 months you need to convert it into a share. You can no longer continue to hold it as the same thing. That is the main amendment. Is this clear? Sir, further, in case any bearer of share warrant, now see, this is also good. Sir, what if you guys can have a question? No. Sir, you are telling about companies at 1956. What if, sir, that person is passed away? What if no one comes? Now what to do? Nothing, people. Convert it into dematerialized form. You convert it into a share. and transfer it to, you know where to transfer. Where will you transfer? If no one comes and takes it, where will you transfer? Allah, where will you transfer? You will transfer it to the same account. Which account? You will transfer it to IEPF. Understood? That's what is given here. Yes, sir. You said the question is expected here. No people. The question is expected here. Yo, sir. It's okay. Second, this is the place where you guys can expect a question, and that is important as well. Now, what is this, sir? Now, look at the question, people. This question is important. I've given you the entire. We'll actually try to read this provision from the Bare Act only because it is important. Yes, sir. Okay. Okay, wait. So they have introduced one new rule, people. This new rule is called as Rule 9B. I hope you guys are able to see. You guys are able to see, Yes, sir. So this is a new rule, people. Now, what is this new rule? First, I'll try to tell you the gist. Earlier, people, what used to happen? Listed companies, people, they were pushed and they told that you need to compulsorily convert your shares into dematerialized form. Who? All the listed companies. The next people who were targeted people, another rule was passed that is called as Rule 9A of Prospectus and Allotment of Securities Rules 2014. They passed one more rule saying that all the public companies going forward you need to convert all your shares into dematerialized form. Now they have passed a third rule, people. Now the third rule says, people, the private companies, people, this is the first time it is happening. The private companies has been compelled to convert their shares into dematerialized form. Sir, is it voluntary or voluntary or mandatory? Going forward, even the private companies should also convert its shares into dematerialized form. Now that is what is this amendment. See here, the entire thing is important as well. Rule 9B, issue of securities in dematerialized form by private companies. See here, of course there is exception also, we'll see that. Every private company other than a small company. So if you are a small company, this rule is not applicable to you. Because if you remember in the class also, what was the purpose of small company? I told you when we are seeing definition also, we have this purpose of small company only because compared to other types of companies, you guys will enjoy certain exceptions. The law will be little more easier on you compared to a normal company. So if you are a small company, they are telling you these provisions will not apply to you. Okay, so if you are a private company other than a small company, for small company, dematerialization not required. Shall within a period referred to in sub rule 2. What is it? We will see. Technically 18 months is given. So what should they do? They have to issue the securities only in the dematerialized form. Securities meaning what, people? Debentures, preference, equity, everything will come. It has to issue only in dematerialized form, it seems. Okay, and facilitate dematerialization of all its securities. So if you are issuing anything going forward, that has to be in dematerialized form, and whatever your existing securities are, that should also be converted into dematerialized form. Okay, in accordance with the provisions of Depositories Act, whatever we have seen. A private company which as on last day of a financial year ending on 31st March 2023, so as on, people, 31st March 2023, as on 31st March 2023, now the lawmaker asked you one question. Are you a private company? Yes, sir, I am a private company. Okay. What type of private company are you? Are you a small company or a company other than small company? Sir, as on 31st March 2023, I am a small company. Then get out. You are not covered here. Sir, as on 31st March 2023, I am not a small company. I am a company other than small company. Then going forward, whatever I read will be applicable to you. Now, what does that see here? So as on 31st March 2023 is not a small company. So I'm a normal company. I'm not a small company. As per audited financial statements for such financial year shall within 18 months of the closure of such financial year comply with the provision of this rule. Meaning what, people? You need to convert your securities into dematerialized form within 18 months from 31st March 2023, and that will come to people your September 30th 2024. That is the last day given. Or will there be any extension? I think there might be an extension. It is not so easy to convert private companies into dematerialized form, because that's a huge step. And it's a very good step also, people, because going forward, fraud cannot happen. As a company secretary, that's a very good welcoming move for you, because in physical records, people will do something and all. As long as these become digital, that is when your purpose will be more and more required. People cannot manipulate. That's the main reason. Understood? Okay, see here. Now, the next one. Every private company referred to in sub-rule 2, making any offer for issue of any securities. So, if you are issuing any securities, if you are going for buyback, or issue of bonus or rights offer, if you are issuing any fresh securities, if you are going for bonus, buyback or rights issue, if you are doing any of these four, after the date when it is required to comply with this rule, shall ensure that before making such offer. So imagine after September 30th September 2024, if you want to issue any securities, if you want to do buyback, bonus, rights issue, then it will ensure that before making such offer, entire holding of securities of the promoters, directors, KMP has been dematerialized accordance with this provision. Meaning, going forward, after this, if at all you are doing any of these four, first dematerialize your promoters, KMPs and directors shareholding. First dematerialize that. That is mandatory, it seems. Okay. Okay, they are covered. What about others? Now see here. Every holder of securities of the private company referred to in sub-rule 2, meaning rest all. I am not a promoter, I am not a KMP, I am not a director, I have still invested in one company. What about me? You are covered in here. They say, who intends to transfer such securities on or after the date when the company is required to comply with this rule shall get such securities dematerialized before the transfer, or who subscribes to any securities of the concerned private company, whether by way of private placement, bonus, rights, on or after the date when the company is required to comply with this rule, shall ensure that all the securities are already dematerialized. Okay, the prior, okay, understood. Now what they are telling you, sir, if at all I am a director or promoter, then I was covered. If at all I am coming up with the bonus issue or buyback or rights, then I have to convert. What about the existing holder? They're telling you if you are an existing holder, then I'll ask you two questions. What? If you continue to hold the securities as it is, the same thing is applicable to private company also. I believe I told you in the class. If you continue to hold the securities as it is, meaning you don't want to transfer, you don't want to buy more shares, then people, no problem. You can hold it in physical form only. But if at all you want to transfer your securities, meaning you want to gift it, you want to sell it to anyone. Now this, if you want to do, first you need to convert it into demat and only then you can do. When people after September 30th, 2024, after that if you are still holding it and if you want to transfer it to anyone, people, you have to first convert it into demat mode and only then you can do it. Or who subscribes to any securities, meaning imagine the company is coming up with a private placement. You want to buy more shares. First to convert your existing ones also into demat and then only you can buy. Imagine you want to subscribe to the bonus shares. Imagine you want to subscribe to the rights issue. You can do it only after converting your existing securities into demat mode. Only after that you can buy the extra share. Is clear, Ram? That's the amendment. And not only that, sir, one more company is also exempted here. Who is that? Look at the last provision. The provision of this rule shall not apply in case of a government company. So for a government company, the entire provision is exempted. So two people are exempted from this rule. Who are they? One is government company, one is small company. That's what is given here. Now try to read this. According to the amendment now, mandatorily dematerialization requirement is applicable on all securities of every private company, excluding small companies and government companies. Understood? A timeline of 18 months is provided from the closure of the financial year in which a private company is not a small company. Which financial year this is? This is 31st March 23. As on that day, if you are not a small company, then people, you have to mandatorily comply with this procedure. The mandatory requirements. Understood? Pakkana, 100%. Okay. Done. So I believe this is a little, this part is important. Going forward, you will see a little big rules also getting added, but we have already seen that is the entire rule. Then all of you are done. That's rule 9B of PAS rules. If you guys want to do more research, you are free to do. Okay, next one, sir. What is this, sir? Okay. There is a additional few points have been added in the existing rules only. With this rule, sir, this rule is people technically are seeing section 89. What is section 89, sir? Nothing but disclosure of beneficial interest. If you remember form MGT4 or MGT5, so there people there is an amendment. What is that, people? This was already existing rule. If you remember, you used to file MGT4, MGT5, MGT6. We used to file it. We used to forward it to registrar. We used to see this, correct? Sir, now what is the amendment, people? Now imagine what was this MGT4, 5 and 6. Whoever is the beneficial owner and whoever is the beneficial owner and who is not the registered owner, or whoever is a registered owner but not a beneficial owner, what they used to do in MGT4 and MGT5, they used to give a disclosure to the company. What will the company do? Company will take the disclosure from the beneficial owner as well as a registered owner. They will further forward it to ROC. Correct? Now my question is, who will forward? In every place it is written as company. But if at all it is not done, whom shall we hold responsible? Now they have added who are those people who will be responsible. So when I am telling you a company has to forward MGT 6 to ROC, who has to forward? They have added the details. Who are there? Now see here. Every company, now from here, from rule 4 they have added. These are the few points added to the existing rule. Every company shall designate, from importance point of view, okay, it is important. Comparatively, rest all the amendments are okay. Every company shall designate a person who shall be responsible for furnishing and extending cooperation for providing information to the registrar. He is coordinating it. Who will say? Or any other authorized officer with respect to beneficial interest in the shares of the company. For the purpose of this rule, the company will designate. So the company may designate these people. Who? First one, a company secretary. Sir, what every company will have company secretary? Yeah, we know that. Rule 8 and Rule 8A says KMP. We are not every company should mandatorily appoint. No. If at all your paid up capital is up to 10 crore not needed. Agreed? So sir, every company will not have CS. Then what to do? So if your company does not have CS, then this point is not applicable. Read. If a company, so you have to appoint, designate a person. Who is that person? First preference is given to company secretary, if at all appointed. If there is a requirement of appointment of such company secretary. If not, this point is not applicable. Or when CS is not there, it can be any other KMP. It can be whole-time director, managing director, manager, CFO, CEO. It can be any of these people. When other than company secretary, or sir, what if KMP is also not there? What if CS is also not there? Then it will be every meaning every director is responsible if there is no company secretary or KMP. Understood? Okay. Sir, what if you are telling here a company may designate? I believe you guys saw the word also. Meaning, sir, is it optional now? Yes, the optional only. You designate whenever you want. Wow, sir, that's brilliant. Until you designate, I will assume who is the designated person. If you do not nominate, I will only nominate. Ayo sir, how is this? I'll tell you who is that. Yes, sir. Okay. Now see here. A company secretary, there is no requirement. Okay. Until a person is designated or as referred above, the following persons shall be deemed to have been designated person. Meaning you are assumed to be the designated person. Who is it, sir? Mitro, ये आप है. Who is it, sir? ये है company secretary. If there is a requirement of appointment, meaning people, if a company, for them CS appointment is required, and if they have appointed Mitro, then that is you people, CS will be the first person that is a designated person. So what if this requirement is not applicable for us? Then people, it will be every managing director or manager in case there is no company secretary. Every MD and a manager will be responsible. Sir, what if we do not have MD or managing director, sir? I mean manager, then every director, if there is no CS, MD or manager. Yes, every company shall inform the details of designated person in the annual return. Whatever is your NGT 7, NGT 7A, whatever you will be filing it, in that you need to clearly disclose who that designated person is. That's what is the amendment. That's what they have added here. Is clear? Sir, further in case of any change in designated person, can I change it, sir? Today I made it, I appointed a CS. Tomorrow can I make my managing director a designated person? Yes, possible. Just that you need to intimate in the form called as GNL2. Yes, you need to intimate to ROC. Okay, done. Next one, sir. Okay. The next one is called people compromise, arrangements and amalgamation. Not a very big amendment as such, but what is it we will see. There was a section people called as section 233. I'll see if I can open the section only and then explain to you. Studying up people, what is happening? I hope all of you are studying the whatever is required. You're solving the questions. That is always very important. Try to take up as many questions as possible. Try to take up test series if possible, because all of that will be very, very important from your exam point of view. Just keeping on reading without knowing what type of questions will be asked is also of no use. That is also very, very important. Remember that. Yes, sir. Okay. And one more thing you guys have to keep in mind is that whenever you're writing the exams, try to write the entire 100 marks, no matter how the paper is. Even if it is difficult, even if it is easy, if you guys have gone prepared, meaning if you think that this attempt makes some difference in your life, no matter what, give your best. Do not come away in between. Never come before your 3 hours. You have to sit for the entire 3 hours. So keep all those things in mind. Those things play a very major role, very important role in your results. Yes, sir. Okay. This is not opening. Okay, we'll see one more place. Okay. Now what is it? I'll tell you just only people. This is not opening only. If it is this part was opening, it would have been easy. Okay, now see here people, now what is this people? If you remember section 233, you remember a section 233, merger amalgamation of certain companies. Which are these companies, sir? That holding company, wholly owned subsidiary, that small companies or startups. Sir, for them we used to see something called as like a fast track merger, no? Yes, sir. So sir, now what they're telling people, in these companies, how did the merger happen people? If you remember, you used to prepare a plan and you will submit the plan to three people, central government, liquidator and ROC. If liquidator and ROC, if they have any problem, if they have any objection, you open the chart we guys have drawn. If liquidator and ROC has any problem, they will give their objection to central government. If at all any objection is filed, then what will central government do? Central government will consider the matter. If it is not in the public interest, then central government will forward the application to tribunal. The central government will tell, then do one thing, your application will not come under fast track merger, take it under regular method. Now you need to go under 232. So from 233, I will send your application to NCLT. So it will go under 232. Correct? What if there is no objection people? Then it will be considered as central government will feel that there is no objection. That means it is fine. So central government used to grant the fast track merger. That's all. Correct? So here there is an amendment. What is amendment people? The procedure is still same. Just that people, they have added timelines. How long do you want me to wait? So once I give my merger plan to ROC and liquidator, how long should I wait for them to submit an suggestion, or how long should I wait for them to object? So for all that they have given some timelines. That's all. Yes sir. So what is that here? As per the amendment, where no objection or suggestion is received within a period of 30 days of receipt of copy of scheme under section 233 from the ROC or official liquidator. So this is what we had seen. Sir, ROC or official liquidator, if there is objection, they will file it with central government. What if there is no objection? Sir, and how much time is given to you? 30 days. Once you guys got the scheme, you guys have to respond within 30 days it seems. Okay. And the central government is of the opinion that the scheme is in public interest. So even they did not object. Central government also feels there is no problem. Then it may within a period of 15 days after the expiry of 30 days. So these people did not respond at all. So how much time I need to wait? I need to wait for 30 days. Once the 30 days period is over, within 15 days from here, the central government shall issue a confirmation order of such scheme in form CAA 12. They have added these timelines. 15 days and 30 days has been added. So you guys have to respond within 30 days. If you do not respond people, the expiry of after 30, I will wait for 15 days. Within 15 days, central government has to issue a confirmation order. Now they have added one more thing also. What is that, sir? However, if central government not issue the confirmation within a period of 60 days of receipt of the scheme under section 233(2), then it shall be deemed that it has no objection to the scheme and a confirmation order shall be issued accordingly. Now what is it, sir? You have received the scheme, sir. It's been 60 days people, even they did not object. Within 60 days, if you did not do anything people, then they are telling you what? It will be considered as a deemed approval. Earlier, this deemed approval concept to this timeline and all was not there. They have added this now. Understood? Pakkana? Okay. Okay. Further, now you saw a scenario where there was no objections. The next one is, what if there are objections? Further, where objections and suggestions are received within a period of 30 days. They have given it seems. Of order from the ROC or liquidator, they have given it to you, or both, by central government, you have given it to them, and such objections or suggestions are not sustainable and CG is of the opinion that the scheme is in public interest or creditor's interest, then it may within a period of 30 days after the expiry of 30 days referred above issue confirmation order in form CAA 12. Now what is this, sir? The ROC or official liquidator, they have responded within 30 days that yes sir, we have an objection. Central government takes up this objection, but central government feels that whatever they are saying it as an objection, it is not valid. This merger is in the public interest. So now what will central government do? Central government will give a deemed, it will approve your scheme. They have given you timeline, and the timeline is people 30 days. See, within a period of 30 days, after the expiry of 30 days as referred above. What is the expiry of 30 days above? Once official liquidators, their 30 days is done. Now I have a right to look into the application for 30 days. The CG is of opinion that scheme is not in public interest. Sir, Central ROC or official liquidator, they also said that we are objecting it. And central government also feel, yes, this merger should not happen. Both of them feel the same thing. Then it may within 60 days of receipt of the scheme file an application before the tribunal in form CAA 13 by stating its objections and opinion, requesting tribunal to consider the scheme. The same thing we saw even the previously also. I will write an objection and saying, a tribunal, this cannot come here, you take it under 232. Now same thing they have added the timeline called 60 days. Within 60 days of receipt of the scheme, it has to file an application before the tribunal in form CAA 13. The application also has not changed. It was CAA 12 and 13 only. That also has not changed. It is still same. Understood? Okay. In case central government does not issue confirmation order or does not file any application to tribunal, then it shall be deemed that it has no objection. Sir, what if, sir, ROC or official liquidator has given objection, but I do not forward my objection report to tribunal. CG does not respond at all. It will still be considered as a deemed approval only. Understood? Yes, sir. So the deemed approval and timeline has been added. That's all. More or less, that's the maximum important thing, and nothing else is there. Okay, next one, people, in dormant company sims. Now, what is it, sir? Earlier, we used to give something as an attachment. Now, that is not required. Now, what is it, sir? By stating that if the company is having any outstanding unsecured loans. So, imagine, people, if a company is applying for dormant status, here you need to file an application called MSC1. In the attachments, people, you need to give certain attachments to ROC. So in that, under those attachments, people, you would have written a big list of attachments. If at all company had any unsecured loans, you had to take a consent, basically a no objection from this, the creditors as well. That we don't have a problem, you can go and apply for dormant status. Now people, they have made a change here. What is that? They have modified, if the company is having any outstanding unsecured loan, then enclosure of concurrence means consent from the lender in the form MSC1 is not required. Now this consent form is not required. Next one, also that the requirement to enclose certificate in form MS1 indicating that there is no management or ownership dispute. Earlier what used to happen, we used to tell ROC that we don't have a problem in the management. There is no dispute going on, no suits are going on. We used to give a declaration. Now they are telling that is also, people, not required. Is dispensed with. Dispensed means, people, it is removed. Clear? Sir, why, sir? Earlier we used to give these two things as a separate attachment, people. Meaning form used to be there. We used to file these two things as an attachment. Now what they have done, in the form only they have added two clauses as a declaration. Both the information above, whether there is any unsecured loan, you need to say tick mark. So in the form only they have added these two options. That's what is given here. The form MSC1 is modified to include these requirements. What are these requirements? These two. That is, one is with regards to the creditor's part and next is with the dispute in the management. Under the heading declaration in the form itself. So in the form only they have added. So directly you guys can click yes or no as the case may be. Clear or done? Simple, huh? Next one, sir, in directors, there is a case law now. Okay, in directors chapter, people, they have added few case laws. What I have done, so they have added big case laws, and we will big. Yes, sir. They have added big case laws. So what I have done, I think I should have added it somewhere. Okay. So they have added 4 case laws, people. They have added 3 case laws. In that, the case laws are big. What I have done is I have given you something called a summary. The same thing only I have given you in some 2 or 3 paragraphs. Read that, it is more than sufficient. So first I will explain you what is the first case law. So in this Anuj Mittal and another versus Union of India, what happened in this case law? Simple, people. There was a director of a company. This company did not file financial statements and annual return with ROC for 3 years, people. They have not filed. Now, because these people have not filed for the 3 financial years, people, I believe you guys know, disqualification of director. So these directors were disqualified. So accordingly, what did the company, what did the ROC do? The ROC suspended its DIN and its digital signature certificate. That means, people, these 2 things were deactivated. Meaning, going forward, they cannot sign anything and their DINs were deactivated. Now, what happened, people? Because these things happened, the existing company almost went for winding up. Now, that was also not the problem. Now, because of their current disqualification, if you remember your 164 and 167, if you do anything there, it will also be a vacancy of directors in other companies also. So, because of that, people, because their DIN and DSC was deactivated because of non-compliance in one company, in whichever other companies they were directors, or in whichever companies they were proposed to be directors, those companies also were getting affected because they cannot sign or their DIN is not active. Even those things also were getting affected because of this particular move. Now what happened, people? Until 2018, and they extended it also up to 2020, they introduced a concept called as a CFSS. CFSS means, people, companies fresh start scheme. Meaning what? Government had given one option called as, hey, whatever you have done, I'll forget it. It's okay. You pay money and you just clean off all your sin. Just pay the money and clean away your sin. So the option was given to you as one scheme. The scheme is called as CFSS scheme. Now what happened? Whatever is the disqualification, this 164, technically you have to leave the other companies also. Whether can I come under this CFSS scheme and can I make good my whatever non-compliance I've done here? So in this case, it was given that, people, yes, you can make good the loss. That was the whole intention of this CFSS scheme. The company's fresh start scheme, whatever you have done, you can still apply, you can follow the procedure and you can continue in the other companies. Not only that, if you want, you file the financial statements, annual returns, and whatever the company, existing company also, which is being wound up, that also if you want, you can revive. That was the main purpose of the scheme. So technically, is it important now? No, people. 2020 was the last day. So 4 years it's been, but they have added the case law. That's all. That's the entire case law. Clear? Done. Next one, people, Surendra Kumar Singhi versus ROC, West Bengal. Okay, now what is this, sir? Okay, in this case, what happened, people? Okay, simple thing, people, nothing but a company, people, whatever the director's report, annual returns, whatever are the disclosures that they will file with ROC, there was some missing information in all these reports and documents. Whatever is required to be given, these information was not provided in these reports. So what happened? The company ROC, they filed a notice on all the directors, saying that whatever is the action you guys have done, this is a non-compliance. Now, because of this, what happened, people, in whoever are the directors in the company, obviously they were all coming under this non-compliance, violation. Imagine if there is a fine, they need to pay the fine. Whatever the consequences, you need to pay the consequences. In this, people, there was one person, and this person was appointed as an additional director. This person was appointed as an additional director. This person said, first of all, I'm additional director. An additional director cannot be liable for all of these things. I'm not like a normal director. I'm an additional director. In this, nothing but, people, in this case law, the summary of the case law says, an additional director his roles and responsibilities is nothing but it is similar to a regular director only. There is no difference as such. So if you are aware of any consequences, if you know that a company is going wrong, it is your equal duty as well to correct it. You cannot leave it as it is. It will be considered as your non-compliance as well, is what was decided in this case law as well. That is what is the crux of this case law. Clear? Just read the summary, more than sufficient. And the third ones are, okay, what is this? This is a little interesting one only, people. In this case, what happened? There was a director. The director gave his resignation to the company in the year 2013. This was given to the company by the director himself. The company did not forward it to ROC. So on the ROC records, if you look at the list of directors in the company, this person's name is still reflecting. He was still coming. Now wonder what happened, people. In the year 2017, the company did some non-compliance, and the authorities, people, they sent a notice to this person as well. This person was shocked because he left the company in the year 2013 only. But in the 2017, there was a non-compliance for which he received a notice. Now the question is, because his name is reflecting in this particular rule under ROC, meaning it is so simple, people. The ROC is not informed. Is it a valid ground? And can I still make the director liable? Is he liable? Technically, people, there is an option given, people, to the director under Companies Act 2013 only. What was that option, people? You have an option. See, you need to give your resignation to the company. Company needs to file it in DIR 12 to the ROC. If you guys remember in the class, because of this only we had seen one more form. If you think that the company does not forward your resignation to the ROC, if you think so, then you can also do it voluntarily. That's the reason this form was even introduced. But this director did not even file this form as well. But people, if you look at the decision that was given in this court, the court said, people, the director cannot be held liable because of the only ground that the company did not forward the request to the ROC. And when did he leave? 2013. When did the non-compliance happen? 2017. Because of those grounds, you cannot hold the director liable, is what was given in this particular case law. See the last thing only. After the director had resigned, thus the proceeding against the petitioner, meaning the director, are liable to be quashed. Quashed means, people, end it. Whatever cases you have filed against him, it has been quashed, meaning it has to be ended. Yes, Sam. It's quite a surprising thing only, no? Yes. That is what was decided in this case law. Okay. Next one, CSR. This we have covered in the class only, people, under disclosures. So I'm not again going to do it because it's an old one only. So we have already covered it. Okay. Next one, sir. People, this miscellaneous and all is definitely not important because miscellaneous means only, people, this is not there in a syllabus. So it does not fall under any chapter. But wherever it is important, I'll tell you on the face of it. So try to see those things. Okay. Next ones are, first one, there is an amendment difference, people, where, people, it's an amendment with regards to incorporation with OPC. The amendment in Rule 4.2 provides that the name of the nominee of the owner of an OPC shall be mentioned in the memorandum. Yes, we used to mention before also in the nominee clause. MOA will have 6 clauses, no? The last clause you know is called as a subscription clause. The nominee details of the OPC. Once the owner dies, who will be the next member? The details will be given in the 7th clause. That is called as nominee clause. Earlier also it used to be there. And such nomination details along with the consent of such nominee. The nominee should also give a consent, no, shall be filed in form INC 32. So along with your SPICE form, you used to file that as a declaration, and the said form along with the fee as provided in the Companies Act shall be filed with ROC at the time of incorporation. Now, what they're telling you people, we used to just give the nominee name in the MOA. Now they are telling you also have to take a consent from him, and you also have to give a declaration in the SPICE form also that who is going to be your nominee. That has to be included in your main application as well. That's the amendment. Okay. Next one, sir. Conversion of OPC into a public or a private company, not relevant for company law. It can be relevant for setting up. Even in company law also, not so much, but yeah, okay. Whenever you want to convert your OPC into public company or private company, what they have done, people, they have reduced the procedures. They have reduced the procedures, meaning what? Earlier we used to give so many attachments. Now all those attachments are not required. They have reduced the procedure. So which were required to be enclosed in form INC 6. If you remember, to convert OPC into a public or private company, you file INC 6. Other way around also INC 6 only. The company shall file an application for its conversion into private or public other than Section 8 company. Yes, we know we cannot convert into Section 8 company. As provided in the companies with altered MOA and altered AOA. That's all. No other form is, no other attachment is required. Conversion of private into OPC, can we do it, sir? Yes, sir. Just that one more attachment has been added here. If you want to convert a private company into OPC, then you need to take a NOC from the creditor, and that has to be attached to the INC 6. That's all. Next one, sir, they've added one more thing. It seems, where is this? Rule 20 has been modified. What is this Rule 20? Nothing but whenever a company, Section 8 company, if I want to start as a Section 8 company, then what should happen? ROC will give me certificate of incorporation along with these people. I've told in the class also that you need to get a license as well. Now what they're telling you, when ROC is issuing license, what and all are the matters that they will consider of this Section 8 company? Now first thing, sir, can an existing company, now imagine you can become a Section 8 company in two ways. One is freshly apply yourself as a Section 8 company from day one. The next one is today you are a public company or today you are a private company and you want to convert yourself into a Section 8 company. Is this possible? Yes, possible. Now whenever an existing company wants to become a Section 8 company, now they've added a few more requirements there. Now what is that? Whenever ROC is considering your license to give you a Section 8 license, then people, they will look into your financial statements, your board's report and your audit report for how many years, sir? For at least 2 financial years. Sir, what if I'm in existence for less than that? Then has functioned only for 1 financial year, then at least for that 1 financial year you need to give. So minimum 2 years financial statements, audit report, board report you guys have to give. It is just to make sure people there is no fraud happening. That's all. Simple. Next one, there CPAs we saw. This is also not required. Again, this is also strike off only. What is it, sir? Earlier people, anyone can file for a strike off. Now if you want to go for a strike off, first whatever is your financial statements and annual returns. Imagine if I'm voluntarily applying to wind up my company. Until today, I have to first file my all financial statements and all annual returns for all the years. Until the year I'm filing my strike off. Until that year, I need to file all my applications, financial statements and annual returns, and only then I can go for a strike off. If not, I cannot go for a strike off. Simple procedure. Okay, next one, sir. SEBI LODR. People, I told you in the class only, people, LODR does not come under Companies Act. But here and there, we had some information about LODR. If you remember in committees, if you remember in directors, you had a composition of directors in listed company. So here and there it is important. So technically, if you ask me, this entire LODR thing is not so much important. So this entire thing, 1, 2, 3, 4, all this is not so much important. Yes, sir, this is not so much important. Yes, sir, but still what I will do, people, until this point, people, I will upload it as a part 2 of Companies Act amendments only. Watch it for your information, that's all. But technically, is it required for us, sir? I cannot comment it. But if I have to tell it to you, see, as a teacher, I'll say because it is part of the amendment sheet, you need to know. But if I have to tell you as a friend, because it's relevant for capital market, and the same thing is there in capital market as well. Every topic is there in capital market amendment sheet as well. So I don't see a point why the same point has to be put in two different subjects. But yes, I'll upload it. You guys watch it. Because of it is there in amendment sheet, I'll be uploading it. Just watch it. 11th point alone, I'm telling it here. People, every company has to prepare annual report. Listed companies, they have to prepare annual report. Yes, sir. Top 1000 listed companies, for them people, there is one more additional requirement applicable. In your annual report, whatever is the disclosures you make, in addition to that, you need to make a new disclosure, and the disclosure is called as people BRSR core disclosure. What is BRSR, sir? Business responsibility and sustainability reporting. Business responsibility and sustainability reporting. What is this, sir? Nothing, people. You are not harming the environment. You are not making a product. The product life cycle is being such a way that you are not causing any harm to the environment. So what are the measures you have taken? That is only called as business responsibility and sustainability. Sustainability means what are the measures you have taken so that you are not affecting the environment and the next generation is always protected. What are the measures you are taking? You have to give a disclosure. Sorry, everyone has to give a disclosure. Not everyone, people. It is applicable to only top 1000 listed companies based on market capitalization. It is applicable to top 1000 listed companies. Sir, and for others people, it is part of your voluntary disclosure. If you guys want, you can do. If not, it is absolutely fine. Whether you are listed on SME stock exchange or you are listed on a normal stock exchange, it is absolutely optional. So that's one thing they have added. So just know that. The rest of the 10 points, I'll upload it as a second part of the same thing. You guys can watch it if you guys want it. But I will watch it. It's okay. Yes, Sam. Next one. Okay, next one is nothing but you guys would have seen something called as grievance redressal. Grievance redressal means what, people? Whenever there is any complaints filed by people, you guys have to give it. I mean, you have to reply to it. Investor grievances. Sir, within how many days should I reply, sir? You need to reply within 21 days. 21 calendar days. Again, this is also there in your LODR only, people. Not relevant here. You look at the word only. SEBI. So, grievance redressal has to be done within 21 days. Meaning, these people, if they receive any complaints, the companies has to respond within 21 calendar days. Who are the companies? All these people. Yes, certain people you guys might know here. Debenture trustee, asset management company. I think you guys can know intermediaries, portfolio managers, REIT, InvIT. So all these people has to respond to all those complaints within 21 calendar days. Simple, that's all done. And okay, this is not important for us, but still as information I'm telling you. What used to happen, people, because ROC burden is too much, whenever you guys are applying for incorporation of a company, because ROC's burden is increasing so much, what they did is they gave the name approval. If you remember, run application and all they used to file. So this name application, name approval and incorporation entire procedure, this entire thing has been outsourced to one more department, and the department is called as CRC. Now what used to happen with this CRC was, that, now imagine I'll apply for name approval or I'll apply for incorporation of a company. If at all there is any information missing and all, this CRC will send it for resubmission, meaning you need to correct your application and you need to refile it again. Few of the people, applicants, felt that whatever the CRC doing, they are not doing their job properly. They are wantedly rejecting the applications. They will send back for resubmission. We will correct it and send. But still these people are not accepting. So they gave a clarification. CRC issued a clarification. What is that? If you guys can prove with evidence, see, nowhere you will see that. That's why we say MCA is so much advanced. They are saying that if you guys can prove with evidence that whatever is happening, that it is not happening properly, it is happening fraudulently, then we shall take action accordingly. And they also said whenever you are filing an application, the resubmission also will not go to the same person. Imagine in CRC I am working. I sent the file for resubmission. When you guys are filing it again, it will not come to me. It will go to a different worker. They gave a clarification. Not at all required for us, but yes, extra gyan I am just giving it to you. That's all. Next ones are shifting of registered office. Again, what is this, sir? Whenever people, imagine if a company is under insolvency and bankruptcy code. If a company is under insolvency and bankruptcy code, again the IBC part is not there for you. Again, that's why I don't think this part thing will be important for you. Now imagine people, because of IBC, what is that? If at all as a resolution plan, I don't know how to tell you also. Imagine people, a company is stuck in insolvency and you are trying to save that company. As a part of that, you are proposing to shift the registered office from one place to another. From one state to another, you want to shift it because that's the part of the plan. You feel that it is not going to work out in this state, and that's the reason you want to shift it to another state. Because the company is already becoming insolvent. Now someone wants to take it over and they want to shift it. If there is no objection for this scheme, people, then you are free to do it. You can shift it from one place to another place. The approval will be given. It will be allowed. Simple. That's all. Next ones are National Single Window System. It's actually good one only. I'll show it to you also. NSWS. National Single Window System. Okay. NSWS. What is this, sir? Actually, it's a very good initiative from the government, central government. Now, what is this, sir? Using this particular website, people, you can get 642 central government approvals in the same website. Now, if you look at it, people, actually even state is also covered, but not everything. Where is it? Now, imagine, people, I want to do incorporation of a company. Where can I do incorporation of a company? Technically, I need to go to mca.gov.in. What they have done, central government, they have come up with one website. No matter which one you want, everything will come under this website only. And that is only called as NSWS. NSWS means, people, nothing but National Single Window System. For everything, there is a single window. You can come for everything here only. So if you look at it here also, search for MCA. Can you see this? Ministry of Corporate Affairs. Can you see this? Incorporation of a company. And can you see incorporation of LLP? Both has been added to this NSWS. So it's a good move, is what they are saying. Yes, sir. That's what is this amendment. Amendment, Allah people, all these are like extra information. Next ones are, see, this miscellaneous. Technically, this has to go under LLP. But it is coming here. So it is there, I'm just teaching you. Of course, it will be helpful for you for your setting up of paper as well. So what is these amendments are? People, whatever, why did I at least to choose to discuss it here only? Whatever you guys have seen the provision. What is Ben 1? What is Ben 2? What is Ben 3? What is Ben 4? What is Ben 5? If you guys remember, people, add everything as LLP Ben 1. LLP Ben 2, Ben 3, same thing, people. What was Ben, people? Beneficial ownership. The same rules has been now. Whatever was there in Companies Act, same rules now has been made applicable to the LLPs as well. The form names, everything is same. Procedure, everything is same. Just that instead of Ben 1, write LLP Ben 1. Now see here. Identify the significant beneficial owners in LLP, and such individual should make a declaration. Such individual should make a declaration in form LLP Ben 1. So brief analysis, people, see here. You will make an application in Ben 1 now, okay, and the LLP shall report it to RC in Ben 2. You will maintain everything as a register in Ben 3. Same thing, no, there also. So it is LLP Ben 3. Sir, what if they don't file? You will only file notice seeking information Ben 4. These rules are mutatis mutandis. As it is, whatever we saw there is applicable here as well. Simple. Technically, it is not important for you people because it will come under your LLP chapter which is there in setting up. But because Ben concept is there, I am explaining it here. That's all. Done now. Okay, that's all people. These are the amendments from your Companies Act, new syllabus. Technically, if you ask me, there is no amendment at all. But just go through these things, more than sufficient. I've gone letter by letter. This has to be sufficient. Dear all of you, thank you so much. Wish you guys all the very best. And if whatever is the result, please let me know. I'll be waiting for your result. Yes, people. Thank you so much. See you. Bye-bye.